May it please the Court, my name is Leonie, initial M, and I appear before you today as the Defence Counsel representing my client, the defendant Sonny Barger. Your Honour, Mr Barger is being charged with one count of assaulting a police officer pursuant to Section 340, subsection 1B of the Criminal Code Queensland, as well as one count of possession of a thing used to play an unlawful game for the purposes of Section 233 of the same code. Firstly, Your Honour, I shall assert that the thing in question, which has been confiscated for use as evidence in the case against my client, should be excluded from the trial for reason of its irrelevance. Further, it is the belief of this lawyer that evidential argument exists to exclude this current evidence with regard to these charges, thus seeing the latter part of today's matter pursuant to Section 590 AA subsection 2E of the Code. Your Honour, while the contents of the backpack do fall within the definition of a Section 233 charge, this evidence will bear no relevance to the further facts in issue. Possession is defined as having under control. The bag was located in a car belonging to Mr Barger's de facto partner and was not claimed as the property of Mr Barger. The comment made by my client regarding the police officer's behaviour in taking a man's property bears no relevance to identity nor possession. Further, Your Honour, the defence puts forward an application that the evidence presented by the prosecution with regard to the charges against Mr Barger be rejected. I make this argument with respect to the circumstances in which the evidence was confiscated and the attending officer's failure to comply with the rules outlined for him in the Police Powers and Responsibilities Act. Your Honour, I am aware you are familiar with the facts of this case, however I will refresh that which I find most relevant. On the date these events occurred, the attending officer, Constable Hanson, made the accusation that my client was in breach of Section 10C, subsection 2 of the Summary Offences Act. When this accusation was made, Mr Barger immediately informed the officer that the name embroidered on his shirt was in fact not the identified organisation, and the prescribed circumstance ceased to exist at this point. And, Your Honour, even if my client had been in breach of Section 10C, the contents of the evidence found had no relevance to the prescribed circumstance where search without warrant is allowed. Thus, there has been a breach of Section 31, subsection 1, and due to this, the confiscation of the backpack as evidence was unlawful. While, Your Honour, there is no common law rule which says that evidence obtained unlawfully is inadmissible, I implore you to exercise your exclusionary discretion to find it so. In making this argument, I submit reference to cases of Ireland and Bunnings and Cross. This is an issue of abusive process and goes against the fundamental principles of justice ingrained in our legal system. The conduct of Constable Hanson was a mistake. However, from the point this mistake was identified by my client, it became a deliberate breach of the law. The evidence in question is not of a perishable nature. However, it is vital to the case of the Crown. This is an officer and an individual who has come to possess the rank of constable, and thus he should have been well aware what he was doing. It was made acutely clear that the officer had erred in asserting Mr Barger had breached the relevant section and therefore extinguished the prescribed circumstance. The consequential seizing of property as evidence was therefore unlawful, and this should have been clear to an officer, as it is his due responsibility to understand the laws that govern him in the Police Powers Act, Queensland. Your Honour, my client was riding in the passenger seat of a car being operated by his de facto partner, stopped at a red light. It cannot be argued that this amounts to pressing circumstances in any sense. It seems to be a case of cutting corners and in turn a disregard of the law by an individual who is empowered by it. The gravity of the charges laid against Mr Barger are not classed as a serious offence. It can hardly be considered reasonable to set aside the laws that are put in place to protect citizens from abuse of power in relation to a charge for use of an item used to play a prohibited game. As I have provided, the conduct of Constable Hanson in obtaining the piece of evidence in question has breached a statute. The statute of the Police Powers Act no less, which has a primary purpose of protecting citizens from abuse of power such as this. The inclusion of this evidence in a trial process undermines the very purpose of the statute. Section 7, subsection 1 of the Act states that it is Parliament's intention that police officers comply with this Act in exercising powers and responsibilities under it. Further, Section 5, subsection E of the Act states that one of the primary purposes of the Act is to ensure fairness to and protect the rights of persons against whom police officers exercise powers under this Act. To charge an individual for an offence which was only discovered through disregard of the law would constitute a miscarriage of justice. I refer back to the case of Bunnings and Cross, which articulates that where evidence is obtained unlawfully or improperly, To admit it would be an abuse of process. Use of unlawful evidence in order to seek a conviction for a matter as trivial as use of items used to play a prohibited game is too high a price to pay for a crime of this calibre. With reference to Section 130 of the Evidence Act Queensland, I ask the Court to exclude this evidence. That is if, with regards to the arguments presented, the Court is satisfied that to admit this evidence would be unfair to the individual who is charged. Mr. Barger has been wrongly persecuted by the powers designed to ensure equitable execution of the law. My client is an individual who stands at the brink of completely losing his faith in our legal system and thereby lost to the criminal world which we seek to sway him away from. We will destroy any trust possessed by Mr. Barger in the Australian legal system. By allowing the mishandling of justice such as this to occur, we work to push Mr. Barger further from the route of rehabilitation and reintegration into our society as a law-abiding citizen. This concludes the defence's verbal submissions. Thank you, Your Honour.